everyone is in place. So, did you want to reserve time for rebuttal?
We did, Your Honor, 10 minutes.
Okay. Very good.
May it please the court, my name is Jonathan Charleston, and I represent the petitioner, appellant Charles Gregory Cummings. This is an appeal to determine, in a nutshell, whether irregularities or improprieties in the 2023 Town of Pembroke mayoral election involving the petitioner and the intervener, Alan Dow, occurred to such an extent that they taint the results of the entire election and cast doubt on its fairness. Whether irregularities or improprieties relating to the election raise a cloud of suspicion as to the election's result, and whether the totality of the circumstances relating to the manner of conduct involving this election, including consideration of the manner of conduct of prior elections involving the same parties, petitioner and the intervener, Alan Dow, whether or not that warrants a new election. We contend, the petitioner contends, that there are three independent grounds for reversal and remand of this matter. One is that there is substantial evidence of cumulative irregularities that are sufficient to cast doubt on the results of the election. Two, that additional evidence, which is material to the election protests, was improperly excluded. And three, whether former Robeson County Assistant County Attorney Gary Locklear's undisclosed conflict of interest denied the petitioner a fundamentally fair and impartial proceeding. There is a cloud of suspicion. Pursuant to General Statute 163-182-13, a new election is warranted when irregularities taint the results of the entire election and cast doubt on its fairness. The petitioner need not prove that the result would have changed. A cloud of suspicion itself is sufficient. During the hearing before the County Board of Elections, the intervener, Alan Dow, was being questioned about a series of affidavits that had been obtained from folks that lived on properties that Mr. Dow owned. These folks lived in non-traditional homes, tents, campers, things of the like. And there were inconsistencies between the affidavits and the testimony given by Mr. Dow. Then the question was posed to Mr. Dow: who prepared these affidavits? The transcript of the county proceedings indicate that Mr. Dow was reluctant to disclose who prepared or who assisted in the preparation of the affidavits. It was not until Mr. Dow, the intervener's counsel, advised him to answer the question. It was only at that point that Mr. Dow indicated that the person that had prepared those affidavits and had given assistance to Mr. Dow was none other than the Assistant County Attorney for Robeson County.
If I can clarify the timing. So the timing of when the affidavits were being prepared and the timing of Mr. Locklear's employment.
Sure.
What's the timeline?
There is really no hard evidence other than the affidavits were prepared in February of 2024. And Mr. Locklear did not resign or retire or conclude his employment with the county until sometime in April of 24. But one of the pieces of evidence, Your Honor, that was excluded at the State Board of Elections was an email from the county attorney, Rob Davis, to the North Carolina State Bar, which inquired as to whether the county attorney's office itself had a conflict and could not proceed. Okay. What the State Bar said was because Mr. Locklear was no longer employed by the county attorney's office, that the county attorney's office could proceed in representing the State Board of Elections. But what the document actually says, Your Honor, was that Rob Davis, who was the county attorney, recused himself from representation of the County Board of Elections because Mr. Davis, who is the actual county attorney, his father was a candidate in the mayor's election for mayor of Lumberton. So he indicates in the email to the State Bar that he recused himself from the entire 2023 election process and that Mr. Locklear assumed those responsibilities.
And that was him individually, not the office, correct?
That is correct, Your Honor. And from the point that Mr. Davis recused himself, he states in his email that the assistant county attorney assumed those duties. Then that email says, to your point, Judge Stroud, that, quote, at some point, Gary Locklear indicated he had a conflict and needed to withdraw. But there is no mention as to what the conflict was. And in fact, the county attorney assumed that the conflict was that Mr. Locklear had an active lawsuit pending against the town of Pembroke, pursuant to which the petitioner was the mayor. That active lawsuit that was referred to in Mr. Davis's email did not get resolved until well into the 2023 election cycle. Mr. Davis assumed that was the conflict.
Okay, yeah, because I was in reading the email, Mr. Davis, record page 720. Yeah, it seemed to me, I mean, when I was reading it, like that a lot of it was not even about it's about the thing that we were reading about, which was the preparation of affidavits. And it was like a lot of other things going on. I mean, it wasn't till we get to the end that we kind of get to like that. I was confused.
Right. Well, the inquiry, as Your Honor knows, typically when there is a conflict of interest, there's an obligation to disclose what the conflict is, particularly when there's been concurrent representation. And in this case, there would have been an obligation, obviously, to disclose to the Board of Elections what the conflict was, to disclose actually to Mr. Dial that there was a conflict. And because the record shows that Mr. Locklear had also represented the petitioner in an election dispute at some point in time, there was an obligation to disclose the conflict to Mr. Cummings as well. But in this case, the conflict was not disclosed to anyone. It was not disclosed, not even to the county attorney who had to defend this. And so we contend that at a minimum, the administrative body, that being the County Board of Elections, has an obligation to protect fundamental fairness and integrity of these proceedings. And when you consider what the county attorney, Mr. Davis, had to say about this, his concern was that Mr. Locklear, the assistant county attorney, Mr. Locklear had active litigation pending against the town of Pembroke regarding matters that involve personal property, real estate that Mr. Locklear had. But that in and of itself was a potential conflict. And the question is, there is no point in time that was identified by the County Board of Elections or the county attorney to pinpoint when those conflicts arose. All we know is that from 2018 until April of 2024, Mr. Locklear was employed either as the county attorney or the assistant county attorney. So why does that matter? One of the things that's important to the free elections that our Constitution speaks of is that the public has an expectation that elections will be free and fundamentally fair and free of any bias. In this case, it's not there. But what's even more telling about this is that the state board made a determination that the conflict was resolved when there's absolutely nothing in the record, in the transcript of those proceedings that says so. The only thing that's in the transcript is the objection by the petitioner's counsel to the conflict of interest that was raised. The the County Board of Elections did not resolve that conflict. There was not deliberation regarding the conflict of Mr. Locklear. There was not a vote taken about how that would resolve itself. And there's nothing in the record that would suggest otherwise. So what we have then is a conflict that was raised, an issue that came out that was unbeknownst to anybody. It came out through the course of an examination of the witness, the intervener, Mr. Dial, that this conflict was revealed. And the interesting thing, Your Honor, is that Mr. Dial and Mr. Locklear, I would argue, concealed Mr. Locklear's involvement. There was never a representation from Mr. Locklear about, or disclosure about the conflict. And the transcript is very clear, Your Honor, that the intervener, Mr. Dial, was reluctant to disclose who prepared or assisted in the preparation of the affidavits.
And the state board reviewed what the county had done. I think the state board was concerned that the petitioner hadn't shown evidence that this contract attorney's actions, even if there was some sort of alleged conflict, but that had any effect on the results of the election itself. Can you speak to that?
Yes. I think the 9th Congressional District case and a string of related cases stands for the proposition that if the election, the entire election, is so tainted that it impacts the opinions about the fairness of the election, then there is not a requirement that those actions be outcome determinative. In other words, that there's no requirement that you be able to prove that the number of votes would have changed but for that conduct. That was the case in the 9th Congressional District litigation, which is a congressional campaign where, I think it was a 2019 case, where there were a number of irregularities that were going on in that case, and so much so that it generally tainted the fairness of the election. And the court, I mean, not the court, but the State Board of Election in that case said that it was so tainted that you did not have to have an outcome determinative conclusion. And I think that is the argument that the State Board of Elections has tried to make, is that the so what? You know, you can't change the outcome. It was 19 votes. But in the 9th Congressional District case, stands for the proposition, and a line of other cases as well, that when the process is so tainted, that there is not a requirement that it be outcome determinative.
So what are your positions on procedural topics? You know, this is an agency.
Yes.
Subsequently, the petition for review. So successful to appeal, yes. What is your stance on procedural?
The remedy would be to remand back ultimately to the State Board with instructions either to order a new election or to take additional evidence. And so, in addition to the fundamental fairness and impartiality that's required in these elections, and I'll just make one more point with respect to Mr. Locke, is when the legal advisor to an adjudicatory body, in this case, the Robeson County Board of Elections, has a conflict of interest, particularly as in this case when it's undisclosed what that conflict is. The proceeding itself is defective, regardless of whether actual prejudice can be shown. The appearance of fairness is itself a due process requirement. And what we will say also is that the conflict that was raised and determined, there was an expectation that it would be resolved by the Robeson County Board of Elections. I make one further point in all of this as well, that in the transcript itself, it states that Mr. Davis, the county attorney, received feedback from the State Bar that said there is no conflict and that the county attorney's office can proceed. Not even in that case did the County Board of Elections deliberate. It is the deliberative body, that being the County Board of Elections, that has the requirement of resolving those conflicts, those objections. It is not the county attorney, who himself is not a member of the deliberating body. And so even in that instance, there was no resolution.
I want to ask you, we're short on time here. I was a little confused about some of the findings of fact of the board, about just talking about the voters themselves and their residence and whatever. Because part of it, most of the findings are recitations. So-and-so testified that, so-and-so testified that. They're not purely findings. But it seemed to me there's within the findings themselves a conflict, because it says Dial had direct knowledge that voters were residents of Pembroke, but then it also says that he testified he had no direct knowledge as to when any of the individuals claiming to reside on his own properties moved there or moved away. I'm just, it's, the findings seem to be that he knows they lived somewhere, but he also doesn't know when they moved there or when they moved away. And of course, we're talking about his own properties that they're living on, which is unusual for people to be living on the candidate's property. So,
All right. And, Your Honor, I will respond to this by saying that these two contestants, that being the petitioner and the intervener, have a history of protests against one another in 2013, 2015. And so in this case, what was happening was Mr. Dial could not testify as to when folks actually came onto his property, which we contend goes to the whole issue of domicile, because even though you're a non-traditional voter, you still have to meet the domicile requirements to be eligible to vote. Did you, for residency purposes, did you intend to return to this place? Mr. Dial said he had no knowledge about that, okay? And so therein lies the conflict in his testimony, and that's why that finding was identified.
I know you're at your time when you reserve for rebuttal, so.
Yes. Okay. All right. So I think my time, I have 10 minutes. I'm going to pause here and we'll start back. Thank you.
Good morning. May it please the court, my name is Mary Lucas. I'm from the North Carolina Department of Justice, and I represent the State Board of Elections. I would like to reserve 5 minutes for my co-counsel here who represents respondent intervener. My argument is divided into two parts. First, I want to provide an overview of the election process, and then I'll address petitioner's specific arguments. I think it's fair to say, as we're sitting here today, everybody is committed to ensuring North Carolina has fair elections. None of the complaints raised by petitioner about the town of Pembroke's 2023 municipal elections for mayor, even if true, would impact the outcome of that contest. Specifically, in his protest to the county board, petitioner claimed 16 people voted who were ineligible to vote. It's uncontested that Mr. Dial won the mayoral election by a margin of 19 votes. Therefore, even assuming that the voters identified in the protest were ineligible, that they voted for Mr. Dial, and those votes were not allowed, Mr. Dial would still have won the contest for mayor by 3 votes.
Now, I want to just, I know the numbers sound small, and you're saying these things, but of course, we have to look at cases, they apply to all elections.
Of course.
So I was kind of doing rough math. And if this were the same thing were applied to a statewide race, we're looking at like 24,000 votes. Sounds a lot more, let's say if there were like 3 million votes in an election, like this is rough math. But just to make the point that, just because it's a little number,
the point is a good one.
this is a small, but a lot of elections are small.
And the point I'm making is not that those numbers are small, is that the claims that petitioner is making about how the election were tainted are not sufficient to overcome the end result. And that matters whether it's a very small number of votes, as it was in this mayoral contest, or if it's a statewide election with many, many votes. In order to have a new election, it's important that you show that the things you're complaining about, if true, would have made a difference, and that's not the case here.
Well, and I want to clarify something too about the findings. And these were the findings, and tell me if I've got them wrong, that Mr. Dial had people using his commercial properties, addresses to register to vote. Is that correct?
You're talking about the county board's findings?
Yeah.
Yeah.
The commercial properties were not their domiciles, from what he said.
Mm-hmm. That
his daughters helped prepare the affidavits, and they were notaries who notarized them. And I think that, obviously the law is that a notary is not supposed to notarize a document for a family member. that was not a finding, but that was kind of my aside. That he testified he had no direct knowledge of when the people moved to or from any of these properties. And that he had helped some of them to register to vote, and he took them to polls to vote. And he's the candidate. So, I mean, these are the findings.
That's correct. Those are the findings in the county board's decision.
And those are supposed to give people trust and confidence in it being a fair election. I mean, I'm just,
Candidates,
it sound kind of crazy.
no, it actually doesn't sound crazy to me that a candidate would be involved in helping voters get to the polls.
No, we're not getting to the polls, but
that-
having people register using his own mailbox?
I think what Mr. Dial testified to in the transcript is that he and his family have long had a involvement with the unhomed people in the area, that his sister has had a charity that helps them, that he knows these folks, that he's familiar with these folks, and that he has allowed them to live on his various properties. That in itself does not mean there was a quid pro quo. And in fact, he testified very clearly in his testimony before the county board that he didn't pay for votes, he didn't give things of value for the vote, he didn't give rides asking people to vote for him, he didn't give anything of value to the people that he helped because that was just the kind of person he was.
Right, I understand.
So
he's
that's the-
using his own commercial properties addresses and his own address for these voters as their address.
The unhomed lived on his properties, and that is not disputed in this case. And that, in and of itself, does not mean that he gave them something of value for their vote. In fact, the testimony in the transcript that was created by the county board and that was reviewed by the state board and by the Superior Court on a petition for judicial review makes clear that the testimony is that he did not give things of value for these votes.
Right, I realize that.
So I think what's important to realize here is that petitioner had a full evidentiary hearing before the Robeson County Board of Elections. The parties agreed, regardless of the administrative proceeding that went before, the parties agreed on the first petition for judicial review, and the court ordered that petitioner would be allowed to submit additional evidence at that hearing, and he was able to do that. That evidentiary hearing took place 7 months after the 2023 municipal election. Petitioner had months to assemble evidence to present to the county board to validate or to provide evidence of the things that he's claiming of this tainted of election. For his own reasons, petitioner only presented testimony from 2 witnesses, himself and the intervener and winning candidate, Mr. Dial, and he offered 2 exhibits, orders for the new elections that the state board had ordered in 2013 and 15. During this evidentiary hearing, the county board assessed the credibility of the witnesses and considered the evidence and concluded that petitioner had failed to carry his burden to show there was substantial evidence of a violation of election laws or any other irregularity or misconduct that cast doubt on the results of the 2023 mayoral elections or cast doubts on its fairness. Petitioner appealed that decision to the state board, and by statute, the state board was sitting as an appellate court. It applied the whole record test, and it upheld the county board's decision. The supplemental petition that was filed in Wake County was also, and this is the one that was filed October 4, that's the operative pleading in this case. That was before the Superior Court, and it affirmed the state board's decision upholding the county board's decision following a review of what happened during that county board hearing.
And Counsel, was the conflict issue raised in the judicial review as well? I know there was arguments by counsel of it being presented to the state board, but was the conflict issue raised during the judicial review as well?
I believe it was, and the reason for that is the Superior Court did a review of the whole record, and it stated in its conclusions that it didn't analyze things that both impacted the positively impacted and negatively impacted the decision, and that would be that whole conflict of interest issue. And what we have in the transcript is, in fact, the county board was made aware of the conflict, and the conflict as it came up was the fact that Mr. Dial's own affidavit, and we're not talking about the affidavits of the voters, but Mr. Dial's own affidavit was helped drafted by the former county attorney. So that was the issue that was presented as a conflict, and the county board took a break. They stopped the hearing. They went into closed session. They decided what to do, and they sent an inquiry up to the North Carolina State Bar. And they received back information saying that this county attorney who helped draft Mr. Dial's affidavit, who was not running the hearing on the County Board of Elections, the fact that he did that after the fact of the election is not going to impact the hearing before the County Board of Elections. So the County Board had that information from the North Carolina State Bar. They took that information and restarted the hearing with another county attorney, not the county attorney who was representing or had helped Mr. Dial put together his affidavit, participating at all. And you can see that the transcript is in the record at 348 to 351. The affidavit itself is at page 208, and it was submitted to the court, and it was before the court on the motion to intervene. And the fact of the matter is that this work by a former contract county attorney did not impact the election hearing, the evidentiary hearing that the protester was allowed before the County Board of Election.
In reading the request that was sent to the State Bar, it seems to me to be asking if Rob has a conflict. And it's got a lot of things going on in it. And the answer is that Rob does not have a conflict. I'm having difficulty connecting the question that was actually raised at the hearing with the summary of facts that was submitted to the State Bar.
So if you look at petitioner's reply, the appendix, page 2, and that's also the record, 720, they're referring to Rob, the county attorney, and then also Gary, I guess. And I believe Gary is the Locklear, the one who helped Mr. Dial draft.
Exactly.
So at some point, it says in this piece of information that went to the North Carolina State Bar, Gary indicated he had a conflict. So I feel like that issue was raised with the North Carolina State Bar, and it was clearly asked, can Rob, the person who's doing the hearing in front of the county board, can he proceed with this hearing, or just this whole mixed up, lots of people wearing lots of different hats in this little small county, is that going to be a conflict of interest that would impact this protester's right to an evidentiary hearing? The state board came, and there was a phone call as well. You see that in the appendix and record page 719. And it seems clear that there was a conversation about this rather complicated situation. The state board weighed in. That was considered by the county board. They moved forward. They had asked for this request. They had made this request to the State Bar. They got their answer, and they proceeded with the hearing.
But, I mean, what's the question? Because the question he asked is there a conflict for Rob or Ed continuing to represent the board? If there's a conflict, can it be waived by consent of the candidates in the Board of Election? And the State Bar said, no conflict. But is that really the question that came
Yes.
from the hearing?
Excuse me, Your Honor. It seems to me that the answer is answering a two-part question. We have this attorney who did that. Gary did that. And so the question is, can Rob, who is wearing a hat in front of the county board, can he continue, or does that other work by this other person who's a contract attorney with the county board, is that going to create a conflict for his other person, Rob, who's proceeding with the hearing? That's how I read it.
It seemed to me that the question that came up during Mr. Dowell's testimony was more of a matter of, is the fact that a person in the county attorney's office has assisted you in preparing an affidavit. It's not so much that's a problem that in this election protest, that in and of itself, not so much about Rob. Although I understand they're like in the same firm, so to speak.
And
Does that make any sense?
I'm not understanding your question, Your Honor.
He's saying a person in the county attorney's office helped prepare an important document in this proceeding for one of the parties.
Right.
And I think that's a problem. That's what he's saying, right?
I'm sorry, who said, I think, Mr. Davis?
Cummings is saying.
Oh, Mr. Cummings, correct, the
saying,
protester.
Right, he's
Yes.
saying an attorney for the county attorney's office helped my opponent prepare an important document in this proceeding, and I think that's a problem.
That's what the protester said, yes. And they stopped the hearing when he said that.
This doesn't ask that. What Mr. Davis sent to the state bar doesn't ask that. Or not that I can, it's like I said, it has a lot of stuff going on in it. I'm not going to go through the whole thing, we don't have time. But I'm trying to figure out where it does mention a witness testified Gary helped him prepare an affidavit dated so-and-so. The witness was the actual candidate involved in the election, for one thing, which is kind of an important point.
I actually feel like this is included in the request to the state bar. And I'm looking now at the bottom third of the fact situation, which is record page 720, in which it says, at this point, Ed and Rob, who's the person who's running the protest hearing, were unaware that Gary, the attorney who represented Mr. Dial, had represented one of the candidates in the Pembroke mayoral election while still working as an assistant county attorney, but after withdrawing as attorney for the Board of Elections. During the protest hearing on June 25, a witness testified that Gary had helped him prepare an affidavit that was dated February 24, a time when he was working as the assistant county attorney. Since that raised a possible conflict, Rob, who was running the hearing, the evidentiary hearing, who was representing the BOE at the hearing, convened a closed session, explained the issue of the possible conflict, and then announced that the hearing was being recessed to consider the possible conflict and get an opinion from the state board. I think that's exactly what happened at the hearing. That was the conflict raised by the protester. That was the conflict identified to the state bar, and following that identification and explanation, including a phone conversation, which we don't know exactly what happened, but it seems to have gone into this rather convoluted situation, I would surmise. The board, the North Carolina State Bar said, it's not a conflict for you, Rob Davis, who is now representing the Board of Elections, to continue with the hearing. I feel like it was briefed to the North Carolina State Bar, and that's shown by the record. And that was the record that was reviewed by the state board, and they also found that they were going to rely on the North Carolina State Bar's statement that there was no conflict, and also reviewed by the Superior Court. So that's how I flesh out that argument. So turning next to the question of, we've had these issues raised. There are voters, and they were testified about by Mr. Dial, who seems to have known them well. And he testified, not that he knew when certain things happened in their life, when they moved onto his property, when they moved off, but he knew because he lived next door and he saw them all the time, and he's familiar with this population, that they were there for the 30 days before the election, which is what is required for residency under the state board statute, our legislature statute.
So domicile, what is the definition itself?
So if you look at 163-57, that is where our state legislature has said what it means to reside. And what's important when you have somebody who's in a non-traditional housing situation is that they can establish residency based on where they sleep. that can be established above a car wash, on a park bench, and testimony about zoning or title or about a lease is only probative of the likelihood that the person in fact resides at a particular location. So under General Statute 163-57, really the definition is residence is that place a person has the intention of returning. And what we have from Mr. Dial's testimony that was supported by the affidavits, which are something that can be considered by the county board under the board statute, is testimony about where these challenged 16 voters had an intent to return. He didn't know necessarily when they first came, when they last left, but he knew because he's in their world, in their life. He lives next door. He sees them at Hardee's in the morning every day. He knows that they were there for the 30 days before the election, and that is sufficient to establish residency. And in fact, Mr. Cummings, on the other hand, during the testimony before the county board, didn't provide testimony from any of the challenged voters. He didn't bring his investigator, who didn't actually look for these folks until April, almost 7 months after the election had taken place. He didn't provide testimony from the director for the Pembroke Housing Authority, who could have told you whether or not they had leases, but not necessarily whether they had an intent to reside with the mother and baby who actually had the lease and who was in the Pembroke Authority. So what happened is Mr. Cummings has provided this testimony that's actually not relevant to the question of where they resided, and the county board recognized that. It didn't matter when they first came, when they last left. What mattered was Mr. Dial's testimony that they were there, that he had seen them back and forth during the days, in the 30 days before the election. So what we have both is Mr. Dial's testimony and the affidavits that were provided to the county board, which indicates how long each of these people, these 16 challenged voters, had been residents of the town. And in many cases, the testimony indicated that they had been there for years. They weren't in traditional homes, but they were in the town, anywhere from like 1 year to somebody was there for 20 years in a relatively difficult situation. But that's not, under our Constitution or our state law, a reason to prevent them from voting.
So, and like I said, I ask these crazy questions because these
That's okay.
there are cases or precedents and, you know, they affect other things, or they can be. It seems to me, and like I said, it seems like a small number of voters, and maybe this is just a glitch in the statute that, you know, the legislature would have to fix. But it would seem like if you're, let's say you're a person and you own some properties, actually it could be any sort of property, and there's some people who are in non-traditional housing who, you know, live generally in the area, a good strategy to win an election would be to get people registered to vote and have them give them your mailing address as their address, and then when it, you know, offer them transport to the polls at the time of the election. I mean, and you're not asking for their vote. Obviously, they could vote for anybody, but you've given them a place to register. You've given them an address at your property, and then if it's challenged, you can help them and get your family member to notarize affidavits for them, and that's okay under existing state law.
The fact of the matter is, the place that you get your mail doesn't have to be the same place that you reside.
I'm just saying, is that our situation under existing state law?
So in fact, that can be okay if you're not, you can have people live on your property. You can allow them to pick up their mail at the address that they live at.
A candidate can do that, and that's okay under our state law.
Yes, especially because the evidence was clear. Mr. Dial drove people to help them register, not caring if they voted for him or not.
There's any quid pro quo or any
There's not.
vote for anybody or anything like that. I'm just talking about really the appearance. But that's okay under our state law.
As long as the requirements for registering are followed, as long as there is an indication that that person who's a qualified voter has an intent to reside in the area, the precinct that he's voting in, he or she is voting in, then that's okay. And there can be very non-traditional ways of establishing residence that are allowed under our statute, and that seem to have worked here. So one of the things that Mr.
Counsel, let me ask you a question to piggyback on that. Let's flip the scenario. What if the candidate was living on someone's property? Couldn't a candidate live in the same scenario and satisfy all the requirements and run for office? You know, I recall several years back, one county over, I believe the sheriff lived in a camper.
In a camper?
In a camper.
Okay.
And won an election. So isn't it feasible under our state law, and it sounds like an issue for the legislature to take up versus the courts always being forced to be involved in stuff. Isn't it feasible that a candidate could live on someone's property in this scenario and satisfy all the requirements to run for office?
That's certainly possible. And we see that situation, a candidate may have multiple homes. And the question is, which one is the one in which there's an intent to return? In which one has that candidate established residency? What if it's a camper by a river that he's parked on somebody's property? If that's the place that the candidate has an intent to return, then residency is established. So there are certain requirements for what you have to show to be a candidate in terms of, are you a resident of the place that you are running for election in? And I have to tell you, I am not versed. Does that include having to hold title to property in the place, or is it simply residency? And I'm not prepared to answer that question in terms of the candidate's requirements. But before we got further, I wanted to just focus on the fact of what do you have to do to get a new election here in North Carolina? And I think the argument has been made that if there's any taint whatsoever, that you should be allowed to have a new election. But in fact, under the Ramser case, and in this case, getting a new election is a really, really extreme situation. It's a grave remedy, not lightly employed. And at this point, we don't have any reason to think that, and there's the one voter, of course, that Mr. Dial said, we agree, that person is not a resident of the town. So yeah, there's one voter that whose vote has been counted, but would that make a difference? Do we have a whole new election if we have indication that there's one voter who was not a resident of the town? And under Ramser and under our General Assembly statute, the answer is no. We only order a new election. The State Board has only done that if they cannot figure out how many votes might have been impacted. But in this case, we know, because petitioner has been very clearly saying, these are the 16 people. He said it in the first appeal, the second appeal, and he said it at the hearing. Now, petitioner has asked for the right to do more evidence. But in fact, he had all the time in the world, from the election protest to the hearing 7+ months later, to put his evidence together. That was the time for him to put things before the county board. That was his time to develop the record. And at this point, under our laws, it's petitioner's burden of proof, and he must establish the record. And having not done so, this is the record that we're dealing with today, and that's the record on which the State Board made their decision, the Superior Court reviewed that and their whole record, and the record on which you should make the decision today as well. At this point, I see I'm running into my...
Well, I'll give you like 3 extra minutes. We asked a lot of stuff. I asked some long, rambling questions. So you'll have his 5 minutes.
Okay. I really will leave that time for my the intervener, and I just wanted to request that this court uphold the Superior Court and the State Board decisions and determine that the County Board correctly determined that petitioner has failed to show any substantial evidence of a violation of election law or other irregularity or misconduct that impacts the 2023 election, because that's not the standard. Not what happened in 13, not what happened in 15, because if every time there had been previously an election, a new election ordered, that would just snowball. The petitioner has the burden of showing there was a problem with this election. He raised issues regarding 16 voters. None of those 16 voters did he have direct knowledge about. He didn't provide any direct testimony from other people about whether they had resided in the town for the 30 days before the election. Mr. Dial provided that information. That's what's in the record, and that does support the county board's decision, and we ask that you uphold that today. Thank you.
May it please the court, my name is Elliot Abrams, and I represent Mr. Dial. I have 4 points I'd like to address briefly. The first is the conflict issue. Judge Gore, you asked whether the Superior Court looked at that issue. Judge Houston did. It's at record page 836, paragraph 13, where he noted that petitioner maintained his objection and contended that a conflict of interest existed. So we know the Superior Court looked at that. And then looking at the timeline of the conflict issue, I understand why this is something folks want to pay attention and close attention to. It's important. If we look at Appendix 2 attached to the reply brief, we see the timeline that Mr. Locklear left the county attorney's office in April of 2024. Then the hearing at the county board happened June 2024. And then that hearing stopped so that the county board could consider the conflict issue, and it resumed in July of 2024. So Mr. Locklear was not a participant in the hearing. If he was, this might be different, but he wasn't. And so the fact that you had a part-time lawyer who once worked for the county, the question then becomes, is the lawyer who's there now for the hearing able to be there? So the State Bar answered the right question, and there's no reason to go revisit this entire election or have a new election because at one point a part-time lawyer helped someone in his community write one document that could not have impacted the outcome of anything. And second, Judge Stroud, you asked about the notary issue. I'm not super detailed on notary law, but I've looked at Section 10B-20C of the general statutes. It lists what a notary cannot do, and it does not say a notary cannot notarize something for a family member. It just says if they're going to get a benefit. And so I think this is important because a lot of what we're talking about is public policy issues. And if the legislature decides that notaries can't notarize documents in these circumstances, it has to say so, and it hasn't done that. Similarly, this bigger picture issue of, is this okay? That's an important question. But what we see is we have statutes, and those statutes have not been broken in any way. Mr. Dial is allowed to have people live on his property. He's allowed to take people to the polls. He's allowed to have these affidavits notarized. So, is this okay? Well, we have a legislature that decides these public policy questions. But what we have here is a procedural history in which there's been no identified error at any level, and we have burdens of proof. And so when we start with a protest that says 16 people shouldn't have voted, that gets down to one person. So that's what we're really left with, is proof that one ineligible voter voted. There was a margin of 19. And so when you look at the big picture, we have to say, did what happened here violate any statutes? And the answer to that is no. Is there any basis to send this back? Well, the petitioner had 8 months to put together and meet his burden of proof. He then had another month. And so he's had plenty of time to put together a showing that there's been a taint, and it's not any taint. And this is really important. The Clay County case is where this cloud of suspicion comes from. And if I may just finish this point, that case involved a dramatic conspiracy to pay people to vote, to illegally take absentee ballots and hold them, to have voting occur at the desk of one of the clerks, it's a very different thing than what we have here. And so as we talk about cloud of suspicion, what we're doing, if we set that bar low, is we create a process in which we don't have finality in elections. And so I think what we need to do is stick with the statute, 163-182-12, that talks about irregularities that may have changed the result of the election. That needs to stay the burden of the standard that has to be met, so that we don't have courts deciding elections based on cloud of suspicion, but instead based on the law. The law has been met here. The standard of review has been applied appropriately by Judge Houston below. There's been no error. There's been no showing of any need to send it back. And there's certainly no need to have a new election where from start to finish, the very first allegation was insufficient to show that there would be a difference. And when that's tested, it's that first allegation of 16 voters becomes 1 voter. There's no basis to believe that anything would have been different. All we're doing 2 years later is deciding whether to throw out all the votes and start over. We have to stick with the statute, and if there's a problem, it should be the legislature that decides it. Thank you so much.
In the matter of investigation of election irregularities affecting counties within the 9th Congressional District, State Board of Elections, on its own, initiated an investigation. When all of the irregularities were brought to the attention of the State Board of Elections, the one thing they did not do in this case was initiate an investigation. The board voted 7-2 to hold an evidentiary hearing pursuant, quote, pursuant to its authority under 163A, 1180, and 1181, to assure that the election is determined without taint of fraud or corruption and without irregularities that, quote, may have changed the result of an election. That's the findings of the State Board of Election in the 9th Congressional District case. There's not a requirement. The legislature hasn't established a requirement at this point for outcome determinative things. To the court's inquiry, the number of votes at issue in this case was 5%. 5% of the votes. 19 votes out of the total cast is 5%. That's material. And there are a couple of other points that I'd like to make, is that, as stated earlier, there's been a history of impropriety and irregularities in elections in Robeson County in 2013 and 2015. How do we know?
Counsel, on that
Yes.
issue,
Sure.
asking you the same question that Judge Stroud asked the board attorney, is what was done prohibited, given rights to the polls, allowing, is there a statute, now that's different than an ethical thing, what statutes, if any, were violated to give the taint on what was done to give rise to the petition?
Sure. Your Honor, if I may answer it this way, the transcript of the county board hearing says that the party stipulated that the entire public record from the 2013 election and the 2015 or 16 election was a part of the record. And the reason that's important is because in the 2016 election, the State Board of Election order, and that's the record, page 660, paragraph 25, quote, the record is rife with several contradictory statements by voters, some of whom appear to confess to involvement in vote buying schemes or to voting improperly. Now, the court inquired as to, and I'm hoping I'm not misstating this, but what we had is a situation where the candidate, for lack of a better word, opened his doors to voters.
Mhm.
They all come live on his property. Okay? He takes them to register and vote. Mr. Locklear and Mr. Dial's daughters prepare affidavits, form affidavits. The affidavits are completed, according to Mr. Dial, by his daughters.
And so, again, let's ask the question.
Right.
And let's take the ethical piece of it out.
Sure.
Give me a statute, the NCGS, that is prohibitive of the conduct, because if we're relying on previous rulings, 2013, 2015, then seems like there needed to have been some pre-election injunctive action versus a reactive, remedy being sought. Because again, not disagreeing with the facts you've recited, but give this court, me and these judges, a prohibitive action that violates an NCGS.
What I will say, Your Honor.
And if you can't, just say, hey, Judge, I can't name one, but, because that's the question that I'm presenting to you right now.
The statute says that when deciding whether or not to grant a new election, that the courts and the State Board of Election can take into consideration the totality of the circumstances.
Don't disagree with you. I'm talking about the actors involved.
Well, I think that the entire underpinning of our electoral process is that elections will be fair and open. Our own Constitution says that.
Yes.
But when you have records that show that there are statements by voters who said that they were involved in vote buying schemes, you have commercial properties now. This is an important point. Commercial properties owned by Mr. Dow. The transcript says that these properties were valuable commercial properties, and they were for rent. It's just hard to put your arms around how you're going to take valuable commercial properties and devalue those properties, unfortunately, by having non-traditional housing on those properties, because they just don't, those don't come together. Folks are not going to come and rent commercial properties where there are camping sites on those properties. Second thing I'd like to bring your attention, statutes say that when you register someone to vote, what happens is that the County Board of Elections then sends a non-forwarding communication to the new registered voter. And that's for purposes of determining whether or not that voter lives there. Mr. Dial testified, it's in the transcript, that one of those places, one of the folks, I believe, lived in his restaurant, and her mail was coming to his address. The whole idea behind this is that you have to get the mail. For instance, there are 2 mailboxes set on this lots that Mr. Dial had. How do you know which mailbox goes with which lot? Okay? And so when you look at the totality of the circumstances that Judge Collins said when the stay was issued originally, that was not done. I think, again, that the transcript and the whole record test in this case has not been complied with. The thing that's really important, and I think Judge Stroud raised the question, was the record at 720. You got to remember the State Board of Election excluded all of this. They excluded Mr. Davis's email. I mean, the State Board of Elections did. It excluded Mike East's affidavit. It excluded all the contracts of Mr. Locklear showing the length of time he worked. And at the time that all of this activity was going on, Mr. Locklear was not at the time a former part-time county attorney. He was employed at the time. And what I will say is that the 9th Congressional District case says you have to look at the entire election process. And Mr. Locklear was a part of that. The whole record test does not stand because there's information that was not in the record. In the transcript, the County Board of Elections did not consider the conflict issue. There was no vote taken to go into closed session. None of that's in the record. None of that's in the record. So when you have the Superior Court reviewing the transcript, it appears that the Superior Court adopted the findings and recommendations of the State Board of Elections, which are unsupported by the record. Thank you.
Thank you very much. Thank you all for your arguments.
All rise. Court adjourned.